Hi, YouTube. Okay, here is the reply brief from the defendants, Morrison County Sheriff's Department, and their attorney, Julia Kelly, from Iverson Roovers Condon. Okay, they had an affidavit that they sent along with the reply that's from the County of Hennepin. Omar W. Yamur, being first duly sworn, states that he is an employee of Bachman Legal Printing, located at Marquette Avenue in Minneapolis, Minnesota. Dated on July 26th, he prepared the brief of Morrison County Appellees, case number 232376, and filed 10 copies of the same upon the following attorneys or responsible persons by first-class mail, postage prepaid. Okay, so remember that their brief was due July 26th, 2023, so they got it in exactly on time on the same day that it was due. And they sent it to the courthouse, though, on the 25th through the electronic filing. So the courthouse got it a day ahead of time. So they said that, oh, they got it ahead of time. Anyway, this was sworn in by Bachman Legal Printing. Okay, keep that in mind. Here is their reply brief. It has a red cover page. You can do colored cover pages if you are an attorney. I think you're required to if you have an attorney. If you're pro se, you are not required to do a colored cover page. Sorry. Okay, so here is court case, appeal brief of Morrison County Appellees. I'm going to point out a couple of the things that should be corrected in there, which we do point out in the reply later, that I will read to you in the next video. But I'll point them out to you, a couple of them, just so you get an idea of what's going on here. Okay, so she says she is counsel for these appellees: Morrison County Sheriff's Department, Sheriff Sean Larson, Mary Swenson, Brady Pundesack, Jason McDonald, Rick Madison, Dave Kicker, Joel Gross, Jason Worley, Tony Athman, Bill Vanden Avond, Haston Warrenberg. Okay, notice there's 12 listed there. We filed the summons, serviced the summons to 19 defendants. What happened to the other 7? I'm not sure. Okay, summary of the case. This is what it said. Appellants Michael Ogren and Wendy Acker commenced this action on January 23rd, 2023. Yes, that's correct. On February 3rd, 2023, appellants submitted their applications asking the district court to allow them to proceed with their suit in forma pauperis, IFP, on March 20th, 2023. Prior to the court ruling on their IFP applications, appellants paid a filing fee based upon the service-related materials filed with the court. Defendants' response to the complaint was due by May 9th, 2023. Yes, that's true. Their reply was due. Okay? Why she brings up the IFP applications, I'm not sure. See, they're trying to talk about our financial ability to pay the fees, and I'm not sure why that needs to be brought into court. Anyway, we were granted that, so that's a non-issue. However, on May 5th, the Honorable Jerry W. Blackwell granted appellants IPF applications, which is a typo, misprint, instructed the clerk of court to return appellant's filing fee and dismiss the complaint under 28 U.S.C. 1915 because he found the claims frivolous and applicants failed to state a claim. On May 25th, Logren and Acker filed a notice of appeal. On appeal, Loger and Acker argue the district court improperly dismissed their claims and that the court discriminated against them based on their socioeconomic disability status. Okay. No oral argument is requested. Okay, so socioeconomic disability. All one word. That is not a protected class. It's two different ones. Table of contents. Summary of the case, table of contents, table of authorities, summary of the argument, standard of review. The district courts properly dismissed Logreen and Acker's claims as frivolous and for failure to state a claim. No evidence of discrimination or partiality. Conclusion. Certificate of compliance. That's their table of contents. Here's their table of authorities. Cases. Barnaboe versus City of Minneapolis. McManamy versus Tierney. Moore versus Sims. Reinhart versus Weitzel. Wilson versus Miller. And the statutes that they talk about in their reply are those there. I'm not going to read them. And other authorities, the 8th Circuit Local Rule 47A. Okay, here's the brief. Summary of the argument. The district court properly dismissed Appellants Logreen and Acker's claims as frivolous. On appeal, despite the statutory authority to conduct an initial review pursuant to 28 U.S.C. 1915 E2, appellants argue the district court's pre-service dismissal was premature. Yes, it was. They also argue the district courts improperly dismissed their Americans with Disabilities Act claim. No, we didn't talk about that too much, and failed to exercise supplemental jurisdiction over their state claims. Finally, they allege discrimination by the district court, yes, yet nothing in the record to suggest it. So, our pages of documents is nothing in the record. Accordingly, this court should dismiss this appeal as frivolous. So that's their basis of their claim, frivolous. Seems pretty weak to me. Argument. Standard of review. The district court's dismissal under 28 U.S.C. 1915 E2B involves a question of law which this court reviews de novo. Moore versus Sims. Number 2. The district court properly dismissed Logreen and Acker's claims as frivolous and for failure to state a claim. Appellants argue the dismissal was premature because defendants had not yet submitted their answer. Appellants do not oppose the district court's approval of their IPF, once again spelled incorrectly. Sorry, I go too close. IPF applications. Appellant's brief at 6. Therefore, on appeal, appellants waive any challenge to the district court's authority to review their case under the federal statute governing IFP actions. Pursuant to 1915 E2, the court shall dismiss the case at any time if the court determines the action is frivolous or malicious, or if it fails to state a claim. Accordingly, the court's review here was not premature, because the statute specifically allows for the district court to dismiss at any time. Further, appellant's case was dismissed prior to defendant's responsive pleading, which is why no answer was required, because the judge answered for them. Okay? Next, appellants argue the district court improperly dismissed their Americans with Disabilities Act ADA claim because nowhere does it require a person to explicitly define a medical diagnosis in order to state a claim. That's what we said in our brief. However, to state an ADA claim under 42 U.S.C. 12132, a plaintiff must allege, 1, that he or she is a qualified individual with a disability, And 2, that he or she was excluded from participation in or denied the benefits of a public services, programs, or activities, or was otherwise subjected to discrimination by the public service. And 3, that such exclusion, denial of benefits, or other discrimination was by reason of his or her disability. Reinhart versus Weitzel, quoting Barbeau versus City of Minneapolis. Here, nothing in the complaint alleges a disability discrimination claim related to Acker. Logreen, on the other hand, alleges law enforcement dispatch incorrectly advised officers he had violent Asperger's disease because he does not have this disability. CR Doc 1 at 10. Okay, so that's our original complaint that they're talking about, and they have no right to even talk about original complaint because this appeal is just to talk about Judge Blackwell's judgments, whether he was correct in his judgment or not. It's not about arguing the complaint because they lost their chance to do that. The time expired for that. Okay, Logreen then fails to allege he has any other disability or that he was subjected to discrimination based on the disability. Okay, so I don't know why they have to keep talking about his disability so much, but everybody knows that Michael has some type of disability, and I do too. So, and there's nothing that we have to talk about because it's confidential to us. We can bring it into discovery as evidence if it should go to trial, but they won't let it go to trial. Okay, so that's why it's a non-issue again, the disability issue. Therefore, the district court properly dismissed Appellant's ADA claim for failure to state a claim. Next, appellants argue the district court unlawfully declined to exercise supplemental jurisdiction over their state law claims. Appellant's brief at 6-7. Generally, a district court exercising original jurisdiction over federal claims also has supplemental jurisdiction over state claims which form part of the same case or controversy as the federal claims. Can this get any more confusing? Still following, people? 28 U.S.C. 1367. But 1367C3 also states that a district court may decline to exercise supplemental jurisdiction over a claim if the district court has dismissed all claims over which it has original jurisdiction. There are no facts or circumstances here that distinguish this case from the unusual case to warrant review of the remaining state law claims by the federal court. They don't want the federal court to look at their state claims, is what they're trying to snake out of. C. McManamy versus Tierney. Okay, when a district court has dismissed every federal claim, judicial economy, convenience, fairness, and comity will usually point toward declining to exercise jurisdiction over the remaining state law claims. Quoting Wilson versus Miller, therefore the district court did not abuse its discretion when it declined to exercise